Required appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to address the requesting the judicial bias and the process violation to the.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
But it's covering all the judicial bias. Okay.
Listen to my question. Is it any different than the last motion to stay proceedings you filed?
Yes.
Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same straight face on you didn't give a shit about what I had to say.
Okay, hold on. Listen, Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers just agreeing telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay. That's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
Constitution against me this entire time. No one has made her answer.
He's back. The same self-proclaimed legal expert who thinks Google qualifies him as an attorney. Judge Oakley greets him calmly, asking which motion he wants to start with. But instead of focus, he delivers confusion, wrapped in defiance. Every answer sounds like a legal riddle with no logic inside it. From the very first exchange, Oakley senses that reason won't survive long. The man's tone is smug, his arguments hollow, and his understanding non-existent. Yet the judge remains collected, steering the chaos with measured precision. The atmosphere feels like a storm forming behind judicial calm. Everyone watching already knows this hearing is about to unravel fast.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, that means you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt of court, criminal contempt in my view.
Yes.
Yes. All right. So now, any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that? I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting it outside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside on what you were doing.
Mr. Crucell, what I was doing was aligning myself with the...
Interruptions start raining in like clockwork, with the defendant talking over the judge as if volume grants authority. Oakley's patience thins, and he delivers his first warning. One more word out of turn equals contempt. The courtroom shifts from discussion to domination, and the tone becomes unmistakably firm. What the sovereign sees as standing his ground looks more like spiraling self-sabotage. Oakley doesn't raise his voice, he tightens his control. It's the sound of authority reclaiming order from chaos. Every second becomes a test of restraint and discipline, and Oakley, seasoned by years of nonsense, passes that test with ease.
The law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt anytime I tried.
I am threatening you with contempt.
My objections on the record to make my case. So you're
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately, properly, and to be perfectly honest, in your best.
Here comes the classic sovereign fairy tale that the judge and prosecutor are secretly plotting together. Oakley asks a simple yes or no question, but the defendant dodges it like truth is radioactive. Without flinching, Oakley drops the hammer. Contempt fine, $100. The man refuses again. Make that $200. Oakley turns the lecture into a master class. Agreement on the law isn't collusion, it's competence. The sovereign, blinded by ego, can't process that logic even when it's spelled out. The courtroom energy hardens into a lesson about consequences. And for the first time, silence speaks louder than his rambling ever could.
Your Honor, again, you're trying to spin this here.
I'm not spinning.
My objection is based on you not allowing me to do it. And that's when you told me my objection to be.
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once it's on the why is it on the prosecutor to prove those things. There's the false words and irregularities.
All right. Let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything that's taking place now shows exactly that there is enough to show. You're supposed you need to keep.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that?
You're fair.
I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me being able to get all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'll like put on record, then if whatever you would like to do from there, you can, because I'm open until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed?
all having
Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Baker Police arrested Mr. Crusoe while he was in Huron Township. The Beaufort District Court has jurisdiction over offenses that occur within the township, both civil and criminal and
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge.
Oakley shifts gears from judge to teacher, explaining that rulings aren't proof of conspiracy. They're part of justice. But to this man, losing an argument means losing freedom. The sovereign shakes his head at every fact like reality itself is on trial. Oakley's calmness feels surgical as he tries to anchor the moment in reason. Yet with each rebuttal, it's clear. Logic can't reach someone who's allergic to truth. The judge's patience is tested, but not broken. The courtroom tension is thick enough to taste. And Oakley's eyes say what words can't. This is going to be a very long day.
And this court ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to...
The judge can't just come in here and say that there's.
Yes, the judge can. Listen to me. Then appeal her to circuit court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they were submitted to the court. These things were never said to me. And then she comes in here and makes these accusations and saying that the judge said this, the judge said that.
Fine. Then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
All the reasons that I'm saying there's.
Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you.
The defendant's favorite word becomes bias, shouting it each time Oakley rules against him. The judge fires back with composure, reminding him that disagreement isn't discrimination. It's the process. Oakley's tone sharpens but never loses professionalism. He tells him plainly, if you disagree, you appeal, you don't argue endlessly. The sovereign just doubles down, convinced the system's rigged because he's losing. Oakley refuses to indulge the delusion, standing firmly on legal ground. Every ruling becomes a quiet statement of strength, and while the defendant sinks deeper into denial, Oakley remains unshaken, a wall of reason against waves of nonsense.
I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever, and I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen,
Mr. Crucell, yes or no? You filed a motion asking me to set aside a decision that was made. Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that a yes or no?
Oakley finally turns into a reluctant professor, breaking down what an objection actually means. He explains that an objection requires a legal reason, not an emotional one. The defendant objects to everything, including gravity, and Oakley calmly dismantles each attempt. It's both frustrating and fascinating to watch. Education colliding with arrogance. You don't know what you're doing, the judge says, and the courtroom freezes. The words aren't cruel. They're true, and even the walls seem to agree. The sovereign glares back, hearing insult instead of advice. It's the perfect example of what happens when ignorance insists on arguing with authority.
Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
essentially, yeah.
Okay.
Prosecutors still.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent, motion for judicial notice. What does that, judicial notice of what?
Certain terms that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Several law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything that's taking place.
No.
Exactly.
No, that's not the way it works, Mr. Cazell. Mr. Cazell, all right, listen, brother, listen. You don't get to tell me what my job is. I've been doing it for 25 years. Listen. Well, then that's why they have appellate courts for the 4th or 5th time. I decide what this jury gets to see today.
The hearing turns into a conveyor belt of rejection. Postponement, denied. Dismissal, denied. Jurisdiction, denied again. Each ruling fuels the sovereign's fantasy that he's the victim of tyranny. Oakley, unfazed, repeats his mantra, then appeal me. But the man doesn't want an appeal. He wants validation. The courtroom becomes an echo chamber of frustration bouncing off hard facts. Every objection is just noise against the quiet force of the law. The judge's patience borders on superhuman as he maintains total control. This isn't a battle between two equals. It's a clinic in how reality handles delusion.
Decide. That is, by definition, the role of the judge at a jury trial. I get to decide what goes in front of that jury. If you don't like the decisions I make, you appeal those decisions. That's the way it works. What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
And that's why I should have tried and I emergency stop the motion to stop this.
I already ruled on that.
Certain back acknowledge my motions for my next travel. Nothing to do.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right? I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
Maybe I said, well, you just keep, each judge has done the same thing. They just keep setting it aside. It's acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my head.
What's your case that traveling doesn't mean operating?
I was having the fact that the court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
Stating an unlawful jury trial, and I think that weighing statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Not participate in a jury in a trial where there is clear bias in this court against it.
Okay.
It violates my rights to a fair trial. 100%. And you want to keep overlooking. Oh, I know they make you seem like they're not a big deal, and
No, your rights are a really big deal.
obviously not, because if you can sit there and say that the things that are happening, the things you're saying, and just try to give these excuses, oh, just because I proved her on this, you are aligning yourself with the prosecutor on my right to trial, completely setting aside, not allowing me
Mr. Purcell, no, I'm not. Listen to me. No, it's not.
Oakley explains the concept of jurisdiction like he's reading from a manual for toddlers. The crime happened here, so this court rules here. The defendant rejects it, as if saying no changes geography. He cites meaningless jargon and fake legal terms that crumble on contact. Oakley uses calm precision, dissecting every falsehood with clarity. But no amount of explanation can fix willful ignorance. Each minute feels like a loop of logic versus lunacy. The courtroom learns, the viewers laugh, and Oakley remains the only adult in the room. When he finally says appeal it, the words hit like a final bell of reason.
God, listen to me. Listen to me. She could step out of the room, and I still think your travel argument is bullshit. Traveling. The right to travel was when you did it by Shank's mare. Appeal me. When you're driving a motorized vehicle or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, which, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling, as you try to apply it, meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
rulings from the American Jurisprudence Society that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this is something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
Complaint as well.
Okay, that's your right. I'm not I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process is working out.
Which is not an appeal.
Is a trained, lawyer when there is bullshit that you can't do that.
Absolutely, I do that.
100%.
No. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this venue, in this arena. That means you got to know the jury structure. Yes, you have.
I'm forced to be.
Now, the sovereign claims judicial misconduct, because what else is left when you've lost the argument? Ironically, he's trying to overturn rulings that actually worked in his favor. Oakley speaks with a tone halfway between pity and authority, telling him, "I'm not biased. I'm trying to save you." But the man's pride won't let him hear it. He doubles down, shouting about fairness while breaking every rule of it. Oakley's eyes show both fatigue and resolve. He's seen this movie before. The defendant mistakes courtesy for conspiracy, and with each outburst, his credibility burns a little brighter into ash.
You didn't have to do it. You didn't have to do it as an untrained layperson. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crusoe, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to me my weather days before any of this even happened and talked to us about the drunken traveler. Even told me I was well within my rights. Gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me. He even called me trying to arena. I was like, what's that over me? And then he goes towards the motor vehicle. And then he tried to get me to not pursue legal matters. And then he's mad at me. And then the day that I file for my body cam, I'm getting removed from here on a Little League.
And stop. Hold on. I don't doubt that it is. But I think we got into this a little bit the first time you were here, and I told you that's not proper for this venue. If you want to complain about the way the Huron Township Police Department handled this, you can file a civil lawsuit against them if you want to. But what's in front of me is one civil infraction and 2 misdemeanors. That's what's in front of me.
Oh, and every time I force it to make my case based.
And finally, the grand finale, the sovereign citizen's favorite myth. The right to travel. Oakley calmly destroys it with history and law, explaining that travel meant walking, not driving 2 tons of metal. Driving is a regulated privilege, not divine freedom. But logic can't compete with delusion. The man clings to outdated quotes like Holy Scripture. Oakley's delivery becomes surgical, his patience saint-like, his tone absolute. "Appeal me," he says, ending the argument with finality. The courtroom quiets, and for a brief second, truth wins. It's not just a legal lesson. It's a masterclass in dismantling fantasy with facts.